decisions solely based on the evidence and the law, not on a preconceived notion or a political agenda. I have seen no evidence to the contrary in the case against defendant Trump. He is entitled to due process and the presumption of innocence, as are all criminal defendants. No more and no less. I am thrilled to be here in your search for facts and truth. I look forward to your questions.
Thank you, Ms. Wine-Banks. We will now proceed on the 5-minute rule with questions. The chair recognizes the gentleman from California for 5 minutes.
I was told that I had to keep to under 5 minutes, and I did that.
No, you didn't. You went,
No.
you went 7 minutes and 2 seconds, but it was fine nonetheless. The gentleman from California is recognized.
Thank you. It's one of those funny things about written statements. People often come and they haven't timed them. Ms. Wine-Banks, you obviously began your career, or relatively early in your career, with the Watergate investigation. Wasn't one of the major things that President Nixon was accused of, the weaponization of government, using the IRS and so on? Wasn't that part of the final impeachment draft?
Right. I was not directly involved in the impeachment,
Okay,
in the prosecution, but you are correct. The impeachment charge misuse of power.
So we are exactly where you started your career, ma'am. We are seeing the weaponization. Richard Milhouse Nixon was accused, and there was plenty of evidence that he thought the IRS and other tactics would be perfectly acceptable against his political enemies. Here we are again. So one of the questions I'm going to ask all of your attorneys, is that correct? All of you, yes, understand the ethics of the American Bar Association. All of you understand the question of what can be waived in attorney-client privilege, correct? Yes. I'll go right down. Ms. Wine-Banks, is it in fact your prerogative to waive attorney-client privilege? Do you have that right under the ethics rules?
I do not.
Correct.
Only my client does.
Exactly. Only your client can waive it. Mr. Hamilton, same, right?
Correct.
Mr. Trustee?
Same.
Mr. Costello?
Yes, which is why I have a written document of the waiver with me.
And so, although you have a waiver from your client, well, let's just say Mr. Cohen, did not have a waiver from President Trump. Is that correct?
Absolutely.
Have any of you, either individually or seen other people, other attorneys, other than Mr. Cohen, tape their client and then turn it over for a prosecution or other use ever? Any of you? Never.
No. No.
Ms. Wine-Banks, it's kind of interesting that what hung President Nixon was in fact to a great extent the tapes he made, but he made them, correct?
He made them, and they were evidence of crime, and so they fall within a crime fraud exception, and they proved the crime. They were the actual commission of crime.
Exactly. Thank you very much. Mr. Costello, I'm sorry. I'll take my reading glasses off. I'll do much better. We're dealing with an unusual situation. We have a president who was a former president who was never charged with any crimes until he announced and became the lead candidate to run for president. Is that correct?
Yes, quite a coincidence.
Yeah, I don't believe in coincidences happening that often.
Neither do I.
Neither do you. So the question I have for you here today is, have you ever seen uncoordinated a series of state and federal indictments of any candidate or any other person like this, where they're indicted in a state they never went to? They're indicted for documents that they had in their possession that they say they declassified and that they have a right to declassify. They get indicted for a misdemeanor that has already run its statute of limitations, but by linking it to a federal offense, which the state doesn't have the right to charge, they make the case and they're now trying that. Have you ever seen anything close to that in your decades of practice?
No, not at all.
So, Trustee, have you ever seen so many indictments that are novel in how they're put together?
I have not. I'd maybe use the word inventive, but either way, I'm with you on the point.
Mr. Hamilton, have you ever seen, and you know, you're apparently the junior one here, have you ever seen or researched or learned about such a broad array of novel or inventive prosecutions as President Trump is dealing with?
Absolutely not.
Ms. Winebanks, I respect your years of practicing as an attorney. Have you ever seen so many charges coming, dating back so many years, but only coming to pass at this time?
I have.
When did you see them?
Well, let's go back to the fact that it takes a long time to investigate, that there was reason for example, in the New York.
No, I was asking for another example. And since you don't have one, let me just close. I've been up here for 24 years. I was a soldier when Nixon was president. I am appalled that what began with Watergate as a legitimate scandal of the wrongdoing has now become an organized weaponization by this president and his Department of Justice. With that, I yield back, Mr. Chairman.
Gentleman yields back. I now recognize Mr. Goldman from New York for his 5 minutes of question.
Thank you very much. Election interference, huh? That's what this is all about. Ms. Winebanks, there are 4 indictments against Donald Trump. Is that right?
Correct.
And all 4 of those investigations started long before he announced his candidacy for president. Isn't that right?
That is correct.
And in fact, he announced his candidacy for president 2 years before the election, just so he could bring in 3 witnesses and the entire Republican Party to say, election interference, election interference. These investigations long predated it. And this was a specific and obvious tactic of Donald Trump to be able to make a political defense that will never be allowed in a court of law, as Mr. Trusty and Mr. Costello know full well. And all because he wanted to co-opt this notion of election interference because he's a candidate. But let me tell you what is really election interference. Withholding military aid to an ally in the middle of a war in order to coerce and extort a foreign government to investigate a political opponent. Welcoming a foreign country to illegally interfere in our election and then using that interference for his own benefit, as Donald Trump did with Russia in 2016. Spend 1.5 years on a completely bogus impeachment investigation into the president without finding a single piece of evidence of wrongdoing. And in fact, the chairman of this committee said the best evidence of President Biden's wrongdoing was a completely false accusation planted by Russia just before the 2020 election. Interesting timing. As usual, my Republican colleagues on the other side of the aisle are accusing the Democrats of doing all of their misconduct that they engage in over and over and over in an effort to normalize it, in an effort to deflect attention from their own wrongdoing. It is right in authoritarian 101 playbook. But let's talk about this 2-tiered system of justice. Let's talk about lawfare. Mr. Costello, your entire opening statement, as I heard it, was simply to discredit Michael Cohen. Sir, I think you're in the wrong place. Michael Cohen is currently on the witness stand at a trial in Manhattan. And if you have information about Michael Cohen's testimony, you should talk to Donald Trump and his lawyers to see if they want to call you as a witness to impeach Michael Cohen. But you know that coming down here, outside of that courtroom, while that witness is on the stand to try to impeach his credibility and his testimony, is jury tampering. You know it is unethical. You know that you are trying to discredit a current witness at a current trial who is testifying right now outside of that courtroom. You know better, and it is shameful. Mr. Trusty, you and I worked together at the Department of Justice. We had a number of interactions related to organized crime. I had no idea what your politics were. I imagine you had no idea what my politics were, because it doesn't matter. And it's very interesting to hear you now nitpick about the Speedy Trial Act and about what you claim to be unprecedented conduct in Mar-a-Lago. But I'm confident that you never came across anyone who refused a request to voluntarily return classified materials, who refused to comply with a subpoena for those classified materials, who was found to intentionally conceal and hide and obstruct justice by concealing those classified documents. You've never come across, that is unprecedented, I am certain, because that is a clear predicate for a search warrant. When someone obstructs justice, refuses to comply with the subpoena, and Mr. Issa can make up all of the facts that he wants about declaring it to be classified because he thought it or whatever it is, that will be decided in court. All of these cases will be decided in court by a jury based on the facts, evidence, and the law. And all the Republican majority is trying to do here today is lawfare, is interfere in ongoing criminal investigations that our system is perfectly well equipped to handle. And I yield back.
The gentleman yields back. I now recognize Ms. Stefanik for 5 minutes.
Oh, I love being able to respond to the novice from New York. First of all, thank you so much for stating the obvious that political lawfare is in fact election interference. That's what we're seeing with the sham Alvin Bragg trial. Thank you also to the novice freshman member for New York, highlighting that withholding military aid to an ally for a political purpose, just like Joe Biden is doing to Israel. Always grateful for you stepping in it. Mr. Costello, in your opening statement, you said that in the over 50 years serving as a lawyer, you, quote, have never seen the types of politically motivated cases that have been brought in this presidential election season. These political cases are being used as a weapon of war to damage, defeat, or impede political adversaries and their allies. Instead of political warfare, it is lawfare, a cancer upon our collective judicial system. I want to begin with Alvin Bragg's weaponized sham trial in New York. Isn't it true that in Alvin Bragg's campaign for Manhattan DA, Bragg specifically ran on going after President Donald Trump?
That is true.
Isn't it true that Bragg's predecessor, Cy Vance, declined to prosecute President Trump?
That is true.
And the FEC also did not prosecute President Trump.
That is true.
And the DOJ did not prosecute President Trump in this case.
The DOJ referring to the U.S. Attorney for the Southern District?
Correct.
Absolutely true.
And one of the reasons the Southern District of New York turned down this case was because the supposed star witness, according to Alvin Bragg, Michael Cohen, was totally, quote, unworthy of belief. Isn't that true?
Without a doubt.
This is the same Michael Cohen who pled guilty to 7 counts in an indictment that had absolutely nothing to do with President Trump and actually predated the first time he met President Trump, correct?
Absolutely true.
And in fact, this is the same Michael Cohen who perjured himself to Congress. Isn't that true?
Yes.
In fact, when called as a witness in this sham trial, Cohen was asked directly if he was honest during his testimony to Congress. He said no, admitting perjury. But it's not just Bragg's case that is a total sham and illegal political lawfare going after Joe Biden's top political opponent, Donald Trump. This rot goes deep all the way up to the top in the Oval Office. Because when Congress referred this admission of Cohen's perjury to Joe Biden's DOJ, isn't it true that the DOJ has refused to prosecute?
That is true.
Isn't it correct that Michael Colangelo, who was the 3rd highest ranking official in Biden's DOJ, was transferred to Bragg's office to run this weaponized prosecution of President Trump? Isn't that true?
Not only true, but it's unheard of.
Unheard of. It's a disgrace. Do you agree that this weaponization of lawfare goes straight to the top with the purpose of helping Joe Biden's failing presidential campaign?
The circumstantial evidence definitely supports that.
And the unconstitutional gag order on President Trump from New York Judge Merchant is unprecedented lawfare.
As far as I know, absolutely.
And let's go to the daughter of the judge. Isn't it true that she is raising millions of dollars off of this sham case?
Well, I have to say, I've read that in the media. I don't know it of my own knowledge.
It is true.
Thank you.
One additional question. I want to talk about the rigged and unprecedented jury selection process. Isn't it true that Bragg's team asked the jurors if they followed Trump on social media?
Yes.
And isn't it true that they did not ask any of the potential jurors if they followed Biden on social media?
Or Michael Cohen.
Or Michael
Yes.
Cohen.
Yeah.
And isn't it true that 87% of the jurors said they voted for Joe Biden?
That's true,
Is this unprecedented and lawfare jury shopping?
without a doubt.
Without a doubt. Political lawfare for the purpose of election interference to go after Donald Trump. Do you agree?
Totally.
This is one of the reasons that Trump's polls continue to skyrocket. And it's why President Trump will win in 2024 to end the illegal and warped weaponization of the justice system. Because if they can illegally go after Trump, they can go after anyone. I yield back.
General A yields back. I now recognize the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. Chairman Jordan started this hearing by saying, quote, "You can't make this stuff up." But anyone who has followed this committee's hearings since the beginning knows that that's exactly what the Republican members are doing in this committee. We've been making this stuff up day after day and pushing out untruths from Jewish space lasers to the big lie. The big lie. Let's start with that one. The claim that Biden lost the election and Trump really won, in spite of the fact that Rudolph Giuliani and his crew brought 60 cases in 5 different states, lost every single case, even before Trump appointed judges, lost every single case that they brought for lack of evidence. Some of these cases didn't even survive a motion to dismiss. There was just no evidence. And yet my colleagues on the other side, including the chairman, Mr. Jordan, continue to push that big lie that Trump really won the election. And let's talk about Hunter Biden's laptop. We don't talk about that anymore. That was the smoking gun. That was the thing that was going to prove all these theories about wrongful conduct on the part of the president. And then there was Alexander Smirnov, who Chairman Jordan said he represents the most corroborating evidence that we have. The most corroborating evidence we have until he was arrested. He was indicted, then arrested. He's still in custody. Your star witness. Your star witness. This is baloney. And, Hannah Arendt, who was a historian who was in Germany at the time of Hitler's rise, she wrote a book about the origins of totalitarianism. And she talked about the active, aggressive capability to believe in lies, not just gullibility, but the active, aggressive capability to believe in lies. Just as in Germany, the time and the truth catch up to all those lies. And, there's some good people on the other side of the aisle. And I just worry about your reputations and your family's reputations about pushing this crap. We can disagree about things, but when you're pushing stuff like that is harmful to our democracy, and you're of all people, following Donald Trump, dear God Almighty. That's where you're gonna die on that hill? You're gonna die on that hill? Sometimes when someone accuses you of something that you're not doing, they're the ones who are actually doing it. And we're here today to talk about the so-called weaponization of the federal government. So I have here a compilation of letters and interventions that Chairman Jordan has authored and submitted to the 4 cases that are ongoing right now. 3 of them are federal. 1 of them is a state criminal trial. These are all criminal trials in which Donald Trump is a defendant. And so these all represent either threatened subpoenas or attacks on or other types of legal, I guess you'd call it lawfare, attacks on the courts, the prosecutors, and in some cases, witnesses. So even up to last week, Mr. Jordan was calling for the investigation of Michael Cohen before he's a witness about to take the stand, and Chairman Jordan went so far to send a letter to the Department of Justice demanding that it investigate former Trump attorney Michael Cohen for perjury. That was last week before he took the stand. Talk about interference with the legal process and lawfare. That's what's going on this committee. And to be honest with you, I agree with Maria Bartiromo, her frustration. We got better things to do than this circus. With that, I yield back.
Gentleman yields back. The gentleman from Florida is recognized.
From the testimony of Michael Cohen's lawyer, Mr. Costello. These days, you see individuals running for prospective office who claim, if you elect me, I will bring down this public figure or that public figure who disagrees with my political philosophy. Understand that to destroy a political rival, you need not convict that person of a crime. All you must do is leak the fact that the individual is being investigated for a particular crime, thereby destroying his or her reputation and causing that individual to incur legal fees to defend themselves. The net result is, if you can destroy their reputation and bankrupt them with legal fees, you have effectively eliminated or canceled your opposition without ever convicting them of a crime or getting a civil judgment against them. Mr. Costello, I just wanted to say I felt very seen by your testimony that was provided to the committee. But I want to get back to what Mr. Lynch said previously, that sometimes when you're accused of something, it's actually the people accusing you who are doing that thing. Now, you were accused of illegally dangling a pardon before Michael Cohen, right?
Correct.
And that was a lie.
Absolutely.
That accusation could not withstand any scrutiny or review from the Southern District of New York, where Mr. Goldman worked, where other great attorneys have worked, right?
And where I worked.
Right, but that dangling,
Correct.
that accusation of dangling something improper. Remember what Mr. Lynch said. If you're being accused of that, maybe it's the people doing the accusing. Now, Mr. Trustee, you described a searing fact pattern moments ago. You accused a Department of Justice official of an extortionist ploy to dangle a judgeship before a lawyer to get that lawyer to betray their client, Walt Nada, right?
Yes, I have no reason to disbelieve that lawyer.
And who was the Department of Justice official that engaged in that extortionist ploy?
Well, the lead person in that conversation was Jay Bratt, who's still currently assigned to the Southern District of Florida case.
What is that? I mean, for those of you who've been prosecutors, who've dedicated your lives to the rule of law, what does it tell us about the shape of the legal system that you have people with the ability to do what Mr. Costello laid out in testimony, to charge you with a crime, destroy your reputation, bankrupt you, like they're trying to do to Walt Nada, a patriot who served in our military, and then to hear this claim that they were literally trying to compromise the lawyer? How should we reflect on a legal system that permits that?
It's broken. I had a friend of mine from the Department of Justice text me not too long ago, and he said, it's going to take decades for the department to fix itself. And I love that place. I worked there. I was a prosecutor for 27 years, but I am fearful that we've crossed the Rubicon by being ends justify the means, by engaging in selective targeting and differential treatment. And I don't know how it ends or how it gets better, but I'm happy to at least bring evidence about that issue.
Well, and that's why these hearings are so necessary. I think that we would love to stay well constrained within our Article 1 lane. But when we've got this Article 2 process that is unloading on political rivals and Article 3 courts, as Mr. Costello said, the only way to have a check and a balance on that system is for the Congress to step forward and to utilize its tools, the most profound being the power of the purse, but indeed we have powers of impeachment and oversight that are important as well. Mr. Costello, is Michael Cohen a liar?
That doesn't begin to describe him. He lies at every opportunity when it's in his favor. And I mean, I could, if you had a half an hour or 45 minutes, I could start to list the many lies that he told us.
Well, let's just triage them. Is there a single branch of government that Michael Cohen hasn't lied to?
Gee, I think there isn't.
Right. I mean, you really have to work hard to hit the hat trick.
I mean, it's one thing to lie to investigators. And I guess it's another thing to lie to Congress, but to lie to investigators and then Congress and then courts.
Don't forget the judges.
Yeah, the
Claimed he
judges
lied
do.
to the judge too, when he pled guilty.
And it's just so odd. I mean, it's not every day you see someone's former lawyer having to come forward and say, I regrettably have to inform the Congress, the court, whomever, that my own client, I am aware, is a liar.
Thank goodness he was foolish enough to execute the waiver of the attorney-client privilege, because he was trying to implicate Rudy Giuliani and myself in a crime,
So
which was
he even lied
absurd.
about that. He even lied about trying to turn on you. And I guess his lies are defied by his other lies and the writings and the paperwork. And this liar should not be able to hold our elections hostage. And that is why this hearing is so critical. I yield back.
Gentleman yields back. Gentleman from Massachusetts for a point of order? Or unanimous consent, I assume?
Mr. Chairman, I last unanimous consent to submit a compilation of your statements and letters to the 4 trials in which Donald Trump is currently the defendant.
Objection. Gentlelady from Florida is recognized for 5 minutes.
Mr. Chairman, you should recuse yourself. These are all your letters.
Was that part of the unanimous consent request? I didn't hear that if it was. The gentlelady from Florida is recognized.
Thank you, Mr. Chairman. You know, my Republican colleagues claimed a 2-tiered system of justice exists because Trump was indicted for his handling of classified documents and exposing our nation's most guarded secrets, while Republican Special Counsel Robert Hur found President Biden innocent of any wrongdoing. Let's walk through the facts. On May 11, 2022, a year after the archives began repeatedly demanding that Trump turn over presidential records and warned him that they may have to refer the matter to DOJ if he did not cooperate, a grand jury issued a subpoena for Trump to produce the classified documents in his possession. Trump's response to his lawyers was, and I quote, "I don't want anybody looking. I don't want anybody looking through my boxes. I really don't. I don't want you looking through my boxes." Trump even questioned, what happens if we don't respond at all or don't play ball with them? And then Trump added, wouldn't it be better if we just told them we don't have anything here? And, well, look, isn't it better if there are no documents? Does this sound like someone who follows and respects the law? I certainly don't think so. Ms. Winebanks, President Biden didn't refuse to cooperate with investigators for a year, correct? Did President Biden lie about classified documents at his residence, or did his lawyers proactively inform the archives of this fact?
You've stated it correctly.
Unlike Donald Trump, Joe Biden didn't prevent anyone from going through any boxes or materials to search for classified documents, correct?
He welcomed them to his house and his offices.
Thank you. Now let's contrast how Donald Trump acted compared to President Biden. On June 2nd, 2022, even after Trump's lawyer arranged a time to go through each box in a specific storage room, Trump instructed his valet and co-defendant, Walter Nauta, to move 64 boxes filled with classified documents from the storage room to Trump's residence, where Trump knew his attorney would not be searching. After Nauta moved these boxes from the storage room to Trump's residence, Trump's lawyers, unaware that the boxes had been moved, found no classified materials and certified this to the FBI. The FBI relied on the lawyer's certification. Seemingly, for the moment, Trump duped his own lawyers. All that activity took place in my home state of Florida, yet my Sunshine State law and order colleagues on the other side of the aisle uttered not a complaint about Trump's obvious cover-up of criminality and wrongdoing. I know that's shocking to everyone here. Talk about 2 tiers of justice. Now, so we're clear about this, please share with me, Ms. Winebanks, did President Biden ever move materials to hide them from his lawyers according to the Hur investigation?
No,
Did he ever instruct anyone else to do so for him?
no,
Did he ever attempt to hide documents from investigators at all?
no.
Okay, continuing on. In another act of deception, Donald Trump also, quote, attempted to delete security camera footage at the Mar-a-Lago Club to conceal information from the FBI and grand jury, unquote. This was after the subpoena had been issued, which specifically called for security camera footage around the site where the boxes were stored. President Biden didn't delete security camera footage around the sites where classified documents had been stored in his home, Ms. Winebanks, correct?
Yes,
And President Biden never attempted to delete or dispose of any evidence that he knew investigators asked for, correct?
yes.
Thank you. This isn't a 2-tiered system of justice. These are just two men who acted very differently, one compliant, one criminally obstructive. One is an upstanding American civil servant who fully cooperated with an investigation, and the other is a man who took multiple criminal actions to cover up his intentional theft of sensitive public and national security documents. Ms. Winebanks, prosecuting a president or former president comes with many challenges, as you well know as a member of the team that prosecuted President Nixon. In your experience, what would be the impact on our judicial and democratic systems if presidents could never be held accountable?
I think the consequences and the danger of that is enormous. I have long believed that a former president takes the role of any ordinary citizen and can be held accountable. I also believe that the Office of Legal Counsel opinion is incorrect and that even a sitting president could be held accountable, that there is no possible way that even within the outer parameters of a president's responsibilities is the commission of crimes, and that when the evidence of crimes is there, they must be pursued in order to protect our democracy.
Thank you, Ms. Winebanks. And I think it's important to point out that the most clear evidence of why we're here on a Wednesday for the first time, by the way, which, not uncoincidentally happens to be the day that the court is not in session and make it more likely that the defendant is watching, that the purpose of this hearing is to witness tamper. The purpose of this hearing is to try to influence the jury to do things that Donald Trump has a gag order to prevent him from doing, all with his lackeys here on the other side of the aisle, aiding and abetting that goal. Thank you. I yield back the balance of my time.
Gentlelady yields back. Mr. Trustee, did Joe Biden keep classified documents?
Yes, he did.
Did he knowingly disclose classified information?
It appears that he did to a biographer for about an $8 million advance fee.
And what was his motive for doing so?
About an $8 million advance
An
fee.
$8 million motive to knowingly keep and knowingly disclose classified information.
Correct.
But he's getting nothing because he's a forgetful elderly gentleman and he's not going to be charged. And yet they're going after President Trump. Let me ask you this. I want to go back to where Mr. Gates was. Who's Stanley Woodward?
Stanley Woodward is a defense attorney in Washington, D.C. with a stellar reputation for honesty, very intelligent guy, and someone I met during the process of representing President Trump.
But in the context Mr. Gates was just at, he's the one who had the judgeship dangled in front of him, right?
Exactly. He had a Superior Court judgeship pending at the time, so that wasn't out of thin air. And he reported it promptly and eventually swore an affidavit to a federal judge.
And here's what the Department of Justice said to him, quote, "Your guy Walt needs to flip. I'd hate to see you jeopardize your chances for the judgeship." Doesn't get much plainer than that, does it?
Does not.
Is that lawfare at its worst?
Among other words, yes.
Yeah, I mean, I've never seen anything like this. And you've worked with Mr. Woodward, and he's not necessarily on the Republican side of the aisle, is he?
My best guess is he is not.
He's not. But he's a good, honest lawyer, the way the Justice Department is supposed to operate.
He is, and I think typical for him being the person he is of integrity, he doesn't like being in this position. He's probably not thrilled that I'm even talking about it, but the truth is the truth.
The truth is the truth. How about this, Mr. Costello? I swear to God, Bob, I don't have anything on Donald Trump. Who said that?
Michael Cohen about 10 to 20 times.
So not just once, multiple times he told you that while you were his attorney, while you were in consultation with your client, he said that multiple times.
He not only said that multiple times, but he said that after I said to him, knowing that he was suicidal, "Michael, think about this. Isn't it easier to cooperate against Donald Trump than it is to kill yourself?" And he still said, "I swear to God, Bob, I don't have anything."
When you laid it all out, you said, dude, you better cooperate. If you got something truthful on the president, you better let me have it or you're in trouble. And he came back with the exact same statement. I swear to God, Bob, I don't have anything on Trump.
That is correct. And that was my obligation to do that, to fully inform him of what his escape route was, as he called it.
And then he changed his story, right? Then he went on
It suited
TV and
him.
changed his
Exactly.
story.
He changed his story. He turned around, and he's the only one who can do that. You have to believe Michael Cohen in order to convict Donald Trump if there's actually a crime there, which there isn't. But
Yeah.
that's an issue for an appellate court.
I want to read another statement, another line from your statement. You said, Alvin Bragg refused my offer. What was the offer?
My offer was to come to his office and sit down, let him look me in the eye and see if I'm telling the truth. When I had all these documents that showed that Michael Cohen simply was not a reliable witness, that his predecessors in the Southern District of New York decided after they spoke to me with the FBI that Michael Cohen wasn't reliable and they never used him again for anything.
Why wouldn't Alvin Bragg talk to you? Why do you think?
You'd have to ask him that. But I talked to 8 of his assistant DAs.
What was that reception like?
I gave them a Zoom conference interview for an hour and a half before I testified in the grand jury on Monday. And then on Monday, when I testified in the grand jury, they did everything in their power not to ask me the questions that would elicit the exculpatory information.
And is this the same information you took to the Southern District of New York?
It is,
Same information. They were happy to get it.
exactly.
What did they decide? What
Well,
did the
they
Southern District-
decided they did not use Michael Cohen for anything again.
Yeah.
And they didn't proceed against Donald Trump for
They s-
anything.
They saw what anyone with common sense would see. Well, we can't make this guy as our star witness in a prosecution. We can't do that. And they didn't do it. And they didn't bring any charges, right?
That's correct.
And even Alvin Bragg understood that. Alvin Bragg said, quote, he could not see a world in which he would indict Trump and call Mr. Cohen as a prosecution witness, but then he changed his mind. And he didn't change his mind until after President Trump was an announced candidate for president, which I think underscores this fundamental point. This is all about politics. And that's your experience dealing with Mr. Bragg and his team. Is that right, Mr. Costello?
Absolutely. I mean, there's no coincidences here. The fact that Judge Merchan has had all of these cases, and by the way, when he finishes with the Donald Trump case, Steve Bannon is next. Out of all the judges in New York County, somehow they keep on coming up with the same judge. Coincidence?
I don't think so.
I don't believe in them.
I think it's all coordinated. Let me just, in my last 8 seconds, Mr. Trustee, let me just ask you this. When the prosecution alters the sequence and the order of the documents they seized in a raid that broke all precedent in what they did, the physical documents don't match up with the scanned documents. Is that a problem?
It is. I mean, we viewed the materials almost like carbon dating. You could see dates of newspaper articles, you'd see photographs, you'd see an item marked classified. The exact context is an important part of the proof for the government as well as the defense, for the defense attorney. So altering that and not being able to retreat back to some sort of recreation is a serious problem.
And you see the irony, don't you? The irony of Jack Smith mishandling documents all the while he's charging President Trump with mishandling documents. I mean, I don't think that's lost on anyone.
Well, and remember, it came out in the context of correcting a prior statement to the court that there was not a problem with mishandling the documents.
Oh, so they even worse or even better, I guess, is even.
Let's go with
It'd be
worse.
funnier if it wasn't so true. My time has expired. Chair, I'll recognize the gentleman from Virginia.
Thank you. Gosh, Ms. Banks, I'm listening to this, and I guess I'm supposed to be persuaded that the only liar in the platform is Mr. Cohen. Now, help me reflect a little bit, because I want to make sure my memory serves me well. Did the former president of the United States, Donald J. Trump, was he found guilty of lying and massive fraud by the state of New York?
Yes,
So he lied,
he did.
honestly, and he was found guilty of it.
Yes,
So we can speculate about others, but in this case, we have a record. Was he fined by that? He had probably given a little slap in the wrist, right?
they gave him a huge slap in the wrist. And in one of those cases, the judge said that Michael Cohen was credible. So we have that affirmation of his credibility. And the prosecution doesn't pick the witnesses, the defendant does. Witnesses who are cooperating were former co-conspirators, and they do acts in furtherance of the conspiracy and in aid of their co-conspirator, in this case, Mr. Trump.
Well, my. So we can have this theater about a particular witness and his credibility, but we actually have a rendering, a judgment rendered in the court in New York in a case brought by the Attorney General of New York. Is that correct?
That is correct.
Right. And apparently they were all engaged in a conspiracy against this poor innocent former president of the United States. Was that same individual, the former president of the United States, also found guilty in a different court of defamation, and defamation being you lied about somebody?
Yes,
He was found guilty.
he was found guilty of that and of sexual assault.
And of sexual assault. Oh, well, was he fined for that?
Very large fine.
Another large fine. So he lied about his business and was convicted of committing civil fraud in the state of New York and fined almost, well, with interest and everything, close to $500 million,
Correct.
and had to post had to actually post a bond to make good as a surety on that. Is that correct?
That is correct.
Now, the title of this subcommittee, Select Subcommittee, is weaponization. You know, the false premise being that the federal government is all organized to weaponize against innocent, especially right-wing victims. Now, if I told you, given your background, that someone running for president of the United States has said, "I'll be a dictator on day one," out of his own mouth, and we know that there are plans to create huge detention camps that could hold and process millions, not thousands, of immigrants in the United States, and they have a plan to politicize the 2.2 million federal employee workforce by creating a new schedule, Schedule F, and initially start with 50,000 political employees appointed rather than civil service career professionals. Would I be fair to say that sounds like weaponization to me?
It does. Project 2025 is very scary to me, and it includes a weaponization attempt through the Department of Justice. It says in plain language that's what they intend to do if Donald Trump is reelected.
And well, if I were to read, I could read a series of quotes to you, but I'll give it. If I happen to be president and see somebody who's doing well and beating me very badly, I say go down and indict them. They would be out of business. They'd be out of the election. You know who said that?
No.
Donald Trump. On day one of my new administration, I will direct the Department of Justice. This Department of Justice, Mr. Trustee and Mr. Costello want to preserve. On day one of my administration, I'll direct the Department of Justice to investigate every radical district attorney and attorney general for their illegal racist enforcement of the law. You know who said that?
I'm going to guess it was Donald Trump.
And does that sound to you like the weaponization of the Department of Justice to go after political enemies or perceived opponents?
It does.
Thank you. I yield back.
Gentleman yields back. The gentleman from Kentucky is recognized.
I thank the chairman. Mr. Trustee, is it true, or do you believe, I'm going to ask you to speculate on something, that some of these cases are going to get overturned even if they do get a prosecution in their current venue?
Yeah, I do think that when prosecutors are being inventive for historically important prosecutions, that they can collapse of their own weight. And maybe that is for misconduct in Georgia. Maybe that's for a novel felonization of misdemeanors in New York. But I do think that it puts a lot of pressure on the appellate courts, but they may well get to that point where trial judges go along with the game, but the appellate court does not.
So isn't it a characteristic of lawfare sometimes that you don't really care how the case is going to end up, that the process is the punishment?
Sure. I mean, look, for any client, it is strain and stressful to go through an accusation and a trial. It's got to be particularly maddening when you're running for president to be going through that, to be tied up in New York courtrooms for most of the day. So yeah, it is. There's a win without a win for the proponents of lawfare sometimes.
Mr. Hamilton, I wanted to talk about the special counsel office in general. The Appointments Clause of the Constitution says the president shall nominate and with the advice and consent of Senate shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. Are U.S. attorneys nominated by the president and confirmed by the Senate according to the Appointments Clause?
In fact, they are.
U.S. attorneys are held to the Appointments Clause because they are delegated some part of the sovereign power of the United States, such as the ability to make indictments and charge individuals with crimes. Was Jack Smith nominated by President Biden or confirmed by the Senate?
He was not.
He was merely given the powers of the special counsel by Attorney General Garland, wasn't he?
Correct.
I think it's kind of a fallacy that Congress can create this special office and that it will be free of any political bias. Do you believe that Special Counsel Jack Smith is acting independently of the White House?
Absolutely not.
And what leads you to believe that he's not?
So it's not only the novel application of some of these statutes to former President Trump, twisting statutes that this Congress wrote, twisting the meaning of plain language of sections like 1512C, interpreting the Presidential Records Act in a way that precludes Donald Trump from deciding which records are his. There's all kinds of different things that he's doing. But I would say that the manner in which they've been acting, as my colleagues on this panel have testified to, the manner in which they have conducted themselves in their investigation, every step along the way, whether it's cataloging evidence or whether it's statements to the court and everything in between, Jack Smith is acting like a partisan hack. And he has a record of that doing so in the past.
And, you know, according to reporting, Jay Bratt, a top aide to special counsel Jack Smith, met with White House officials multiple times, including just weeks before special counsel Smith indicted President Trump. I mean, it's hard to say that he's independent if these meetings are in fact going on, isn't it?
That's correct.
I think maybe we need a hearing later on to talk about this office itself and how it's been weaponized. I'm going to yield my remaining time to the chairman.
I thank the gentleman for yielding. Mr. Trustee, you've talked about earlier Jack Smith's obsession with getting this trial done before, in a speedy fashion, I think before the election I mean, it seems to me that in and of itself, all of them are concerned. These trials may not happen before why does that matter? We want justice done right. That should be the focus, not some artificial timeline.
I think the speedy trial demand betrayed the political underpinning of the entire process. There's no reason for a federal prosecutor with a non-incarcerated defendant to say anything. And if I could just for a quick sec, the model here, there was a real obvious model that would have given us all more faith in this process. That is full transparency on behalf of the Department of Justice. Coming into court and saying, we're turning over everything in discovery. We're ready for trial, but judge, you tell us, we'll show up when we need to show up. We're here for small J justice, not capital J justice, as we used to say at DOJ. That's the problem. That model of transparency and openness, not fighting special master supervision, not appealing everything, not trashing Judge Cannon in Florida. That's what we could have had some respect for and some belief that the process is playing out fairly.
You only bring charges after he announces for president. Then, of course, you want the trials before the election. That seems so obvious, I think, to anyone with common sense. That's what they're trying to do. Now, the good news is it's all falling apart. It's all falling apart, which when you have these kind of cases, maybe that's what we should have probably expected in the end. I think the gentleman for yielding. The chair now recognizes the gentlelady from Texas.
Thank you, Mr. Chairman, and to the witnesses, good morning. I apologize. I have a competing hearing that I had to sort of play dual role here this morning. While I miss your opening statements, I certainly have looked at what you were prepared to testify to. And frankly, you know, I have some questions, but I'm just sort of still astounded to hear that some of my colleagues are questioning the timing of the charges and all of this poor little Donald Trump got indicted story. I'm astounded by their claim that there's a two-tier system of justice, all because the twice impeached former president was indicted on charges for mishandling of classified documents and Biden was not. You know, that's the bottom line. Biden and Pence were not. It's ridiculous. And I don't say that as a Democrat or as a member of Congress. I say that as a former judge responsible for upholding our Constitution and the rule of law. Apparently, my Republican colleagues need a refresher on criminal law. To convict someone of a crime, a prosecutor must prove each element of that criminal act beyond a reasonable doubt. Prosecuting someone under the relevant statutes in these cases, a prosecutor would have to prove willfulness. Defendants would have to have willingly withheld these documents. Mr. Hur's report cleared President Biden of wrongdoing. But boy, oh boy, did Trump willfully steal and conceal. New mode of operation there, steal and conceal his documents. In his words, when he realized he had the documents in his possession, he didn't call authorities to come get them like President Biden or Vice President Pence did to correct the problem. No, he thwarted every attempt to have federal prosecutors from coming in. Reports say he said, quote, "What happens if we just don't play," end quote, with investigators, and that he didn't want anyone getting, quote, his documents. His documents. He has some strange belief that classified documents are his and his only. So he lied to his lawyers and he lied to the FBI, pretending he didn't have any more documents, when in fact he instructed his aide to hide those documents around his unsecured property in Florida. We've all seen the pictures. He threw them in bathrooms and bedrooms in a building that had tens of thousands of people come through, where 150 members of his staff worked. This isn't a tiered system of justice. It's just the criminal justice system evaluating the facts. Facts Republicans apparently seem uninterested in and want to totally ignore. Because facts aren't what matter to my colleagues across the aisle, as they have proven today. But regardless of how much they try, in America, no one is above the law, not even the former twice impeached president. Ms. Winebanks, you were a prosecutor that worked on the Watergate case. As a former prosecutor, can you speak to what is needed to prove willingness? And do you think that it can be proven in this case with the classified documents?
Absolutely. And I think some of the conduct, which all occurred after he was out of office, including the concealing of the documents, including telling people to delete the video, including everything that he did to make sure that things weren't found. He hid documents from his own lawyer by moving them from where he knew his lawyer would be searching. He caused his lawyer to file a false statement to the FBI about, here's the documents we have. Those are all evidence of his knowledge and his willfulness. He knew he had those documents. He knew he didn't want them to be turned over. And if I could just add, the Presidential Records Act is something that was passed as a result of Richard Nixon's conduct. And so I'm very familiar with it. And it extends to not just classified documents, but to all the records of a president. So he was holding many, many documents that should have been turned over as a routine matter when he left the White House.
And this is opposed to how Vice President Biden and former Vice President Pence handled their requests.
That is correct. And in the case of Biden, the special counsel investigating concluded that there was no evidence of willfulness that could establish beyond a reasonable doubt that he had any knowledge or willfulness in possessing those documents. And there were even specific findings about things like his diaries, which have long been held since Ronald Reagan was president, to be the personal possession. Those are personal documents. The president, former President Trump, tried to say everything is my personal documents. That's not how it works. Personal documents are like the diaries and handwritten notes.
Well, thank you. And I'm running out of time, but would you say that they're really, I mean, I don't even know what this, what are they calling it? Legal affair or?
Lawfare.
I mean, does that word even make sense?
Well, I had to look it up. It's not one that I had ever heard except in terms of the Lawfare blog. And so I looked it up and I was quite surprised at what its meaning was in terms of weaponization. And I think, as I was being asked earlier, the Project 2025 is the weaponization of government.
Well, and this is, they're talking about this from someone who's found countless and countless and countless of lawsuits against contractors, against property owners. I mean, he's Mr. Lawsuit himself. So thank you so much for being here today.
Thank you,
Yield back.
Gentlelady yields back. Gentleman from North Carolina is recognized.
Mr. Costello, I'm over here on this end, sir.
Oh, thank you.
I want to distinguish something. It's extremely bad judgment to put an inveterate, well-known liar on the stand. It's bad judgment for a lawyer to do that because that person's subject to impeachment for his lies. That's true, right?
That is true.
Okay. And impeachment, for those watching, that's when you destroy the credibility of a testifying witness, right?
You do. You also destroy the credibility of the office, which
Absolutely.
is why I wanted to sit down with Alvin Bragg.
But there's another problem with doing that, isn't there? That is to say that the witness might give false testimony while on the stand. And that's something yet further is, how many lies did you testify Cohen testified to yesterday in New York court?
Well, I only read the section that involved me, and virtually every statement that he made about our interaction was false.
Okay. Alvin Bragg and his assistants prosecuting that case, they're lawyers, right?
They are, yes.
Can lawyers knowingly permit their own witness to testify falsely before a court?
Absolutely not.
Is that just a matter of bad judgment or something more?
No, it's a matter of ethics. It's
Okay.
required.
Are lawyers who do that susceptible to punishment for it?
They are susceptible.
If lawyers do that and they're doing so in the course of interfering with an ongoing presidential election, could they be subject to punishment for that?
I would think so, sure.
I noticed that today, in the course of this proceedings so far, not one Democrat has asked either of you a question and allowed you to speak to it.
I not only noticed that, but I noticed that after they take cheap shots, they leave.
Absolutely. Speaking of that cheap shot, Mr. Goldman, he's a great lawyer, by the way, so he knows not to ask you a question.
Well, we've had prior dealings, and I think he does know not to ask me a question.
I'm sure. But do you care to respond to what he suggested?
Well, he's suggesting that this is jury interference. First of all, I had nothing to do with the scheduling of this hearing. And second of all, nobody knew when Michael Cohen was going to testify. The prediction by the media and also by the prosecutors was that this was going to be a 5 or a 6 week trial. So according to that, Michael Cohen shouldn't be testifying for another week or two. So to claim that we're just doing this to interfere with the jury that's been instructed, of course, not to watch proceedings such as this,
Absolutely.
it's ridiculous.
All right.
It's a cheap shot.
So-
And that's why I called it that.
Totally agree. And I'll just observe. When I was reading your statement, I noticed that you said you had been practicing law for 51 years. I said, wow, you're going to be old.
No,
What a great head of hair and great, absolutely have it all together. So but you've been practicing law at a high level for 51 years. Mr. Trustee, next year, I think you said you were with the Justice Department for 27 years. Is that correct?
I was a prosecutor for 17 at DOJ.
Okay, prosecutor, 27 years and 17 at DOJ.
So yes, I'm not as old as Bob.
No.
Thank you for that.
No one has attempted to lay a glove on either of you. How about Stanley Woodward? Has anybody, to your knowledge, challenged his sworn account of being extorted by Jay Bratt, Mr. Trustee?
No, but I also have no evidence of the department looking inward about it at all.
What indeed is the recourse? If this shouldn't come before this committee, as the members of the minority have said. What indeed is the recourse for this? Mr. Trustee?
I'm not sure. It's certainly disqualification from the case, which would be a starting point here. And there should be a robust OPR investigation on the DOJ side. My experience with OPR, even in some of the worst accusations that were made to people in the department, was that they geared it to not make decisions until after the litigation was closed, which was very self-serving. I'm a little concerned that the public ramifications by way of OPR and DOJ's response might be years away.
That seems to be the problem. No one's ever held to account, and the process takes years and years and years and then ends in a whimper with somebody sending a report forth, and the problems just keep coming. I encourage those who are watching, unfortunately, I've only got about 30 seconds left, to read the last two. Actually, both of your statements are extraordinary. Anybody watching this hearing ought to pull those statements up and read them word for word. They're magnificent, well drafted. And the end of yours, Mr. Trustee, in which you characterize where the Justice Department is and how much of a problem this is and how dangerous it is to the country I think are maybe two of the most significant paragraphs I've read while I've been in Congress. And I encourage people to look at them.
Thank you, sir.
Yes, sir. But I tell you, I appreciate your coming here. It is that on both cases, it is an act of service to the country. And I think the American people are wise to this. And I know how it's going to go. The only question is what comes next. How is this going to be dealt with in the next administration? Because be dealt with, it must be. You bet.
Gentleman yields back. Well said, particularly the reference to the gentleman's written testimony. I would encourage everyone to read that. The gentleman from California is recognized.
Thank you, Mr. Chairman. If I might start, since the issue of veracity has come up repeatedly here, if I might enter into the record 3 articles that have recently appeared dealing with the veracity of the former president. One's from Time Magazine, another one from, let's see here, yes. Mr. Chairman, may I enter these into the records?
Well, I thought you were going to read. You said Time Magazine. You said the 2 others, but yeah, without objection.
Thank you. Was this trying to define lawfare And apparently it has to do with using the federal government, in this case, to weaponize or to carry out some action against somebody. Now, if someone were to say, I will appoint a special prosecutor to go after the most corrupt president in the history of the United States of America, would that be lawfare?
I believe it would.
Thank you. If someone were to say, if I happen to be president and I see somebody who's doing well and beating me very badly, I say, go down and indict them. They would be out of business. They would be out of the election. Is that lawfare?
That is definitely a violation of everything that the Department of Justice stands for. It is lawfare. You need to have some evidence to begin an investigation, and the president himself has no role in directing who the Department of Justice will investigate or prosecute.
If I might continue, thank you. On day one of my new administration, I will direct the Department of Justice to investigate every radical DA, Attorney General, for the illegal, racist enforcement of the law. Is that lawfare?
Yes.
Do you know who made those statements? Let me tell you. Those are direct quotes from the new wannabe president, former President Trump. Apparently, he wants to use his power as president to weaponize the Department of Justice and every other federal agency to go after his enemies, political or otherwise. One of these quotes might be his business interest. Would that be inappropriate for a president or a wannabe president to make these statements, and even more so to do that should that person become president?
It would be.
Do any of you gentlemen disagree that that would be inappropriate for a president to do any of those three things? Gentlemen? Yes or no? It's appropriate or inappropriate?
I don't accept the premises fully, so I'm having a
Now,
hard
don't give
time
me
with
that
yes or no.
lawyery business. The question is, those are statements made by the former president of the United States as he prepares to become the next president. Are those appropriate actions by any president? Yes or no?
Yeah. I don't have an answer for you, sir.
I thought you might not. Mr. Costello, are those appropriate things for any president to do? Yes or no?
I don't think that's a yes or no question.
Thank you. I knew you would not answer the question, but I'll ask it one more time. These statements, are they appropriate action by any president? Yes or no?
I would say they're not appropriate.
Thank you. Mr. Hamilton, do you want to opine on this?
Well, like my colleague, Mr. Trustee, I reject the premise of the question
Thank
of
you.
out of
We'll move on.
context statements, but I would say.
We're going to move on. Thank you very much. That's not all that's been said. If we were to go through the various statements, on day one, I will be a dictator. Is that an appropriate thing for an American president to be, or even to say he would be? Anybody want to answer that question?
It is inappropriate.
Mr. Hamilton? Appropriate or inappropriate for a
You didn't
wannabe
want to hear me a
president?
second ago, so why are you asking me now?
I'll answer, it's humorous. I don't think the guy actually thinks he's about to be a dictator.
Exactly.
So you think it's inappropriate to say that?
No, it's humorous. I like humor.
Do you like dictators?
It's not an issue. He served for 4 years as president. I don't remember a dictatorship breaking out.
Time of the
No,
gentleman.
we're talking about.
Time of the gentleman has expired. Mr.
I yield back.
Gentleman yields back. The gentlelady from Florida is recognized for 5 minutes.
Thank you, Chairman Jordan. And thank you to all of our witnesses for appearing here today. I'm just going to start going right down the line with a simple question. When a candidate campaigns for office, they make promises, correct? We'll start with you, Mr. Costello.
Correct, obviously.
Want to be a
Sure.
Mr. Trustee, Mr. Hamilton?
Yes.
Yes.
One makes, wonderful. So I'm going to dig into what the prosecutors and plaintiffs have said about Mr. Trump here recently. Alvin Bragg, during his campaign for New York County District Attorney, said, quote, "I am the candidate in the race who has the experience with Donald Trump. I was the chief deputy in the Attorney General's office. We sued the Trump administration over 100 times for the Muslim travel ban, for family separation at the border, for shenanigans with the census. So I know how to litigate with him," end quote. In response to another question from a reporter, Bragg said, quote, "We've got two standards of justice. Harvey Weinstein, Jeffrey Epstein, being a rich old white man has allowed you to evade accountability in Manhattan. That includes Trump and his children," end quote. Moving on to New York Attorney General James, during the last days of her campaign, said of Trump, quote, "Oh, we're definitely going to sue him. We're going to be a real pain in the ass," end quote. She would later go on to say, quote, "I will never be afraid to challenge this illegitimate president," end quote. And said, "What is fueling," quote, "what is fueling my soul right now is Trump," end quote. Mr. Costello, is there a financial benefit to making campaign promises?
I'm sure there is, otherwise she wouldn't have made those promises.
Mr. Trustee,
I think that's right.
Mr. Hamilton,
Correct.
Ms. Winebanks?
I'm not sure I understand the premise of your question, so I
You
can't
don't,
answer.
you cannot answer if there is a financial benefit to making campaign promises?
Making campaign promises is to win election.
You
I
know,
don't
I'm
see
gonna
that as
sti-
a financial benefit.
I'm going to stick with you, Ms. Winebanks, as the Democrat witness here today. Can you answer how much money did District Attorney Alvin Bragg raise for his political reelection campaign immediately following the announcement of 34 felony counts against President Trump?
I do not know.
It's $850,000. $850,000. That's a good chunk of cash. Let's go on to the AG James. How much did she raise for her political campaign after her civil fraud case against President Trump?
I don't know, but it has nothing to do with whether the charges that she filed were based on the facts and the evidence and her
You and I
ability
both
to
know
prove
that's
them.
nonsense. Come on now.
I do not know that's nonsense. I believe it to
Not
be
a soul
true.
in this room actually believes that. And no one will ever believe that. It was $400,000. $400,000. And we will submit for the record copies of campaign emails soliciting donations. It almost seems, and I'm just stating the obvious here, that the harder they go after President Trump, the more money they stand to make. The common thread between all of these individuals, as well as the other cases that President Trump faces, is that many of the prosecutors suing Trump either have a personal vendetta or they seek to gain fame and money from it. This isn't hard. Those of us here today, we understand politics and what it takes to run a successful political operation. Traditionally, you want to drain your opponent's resources, drive up their negatives in the polls, and you want to keep them from engaging with voters. Now, I'm going to ask the million-dollar question here. What better way to do that than to charge your opponent with 91 counts, force them to spend millions on a legal defense, and tie them up in court to keep them off of the campaign trail? It's almost like this is a plan. This is a strategy that is employed in campaigns all around the country, but we are seeing it at the highest levels today. Of course, as an incumbent, you have an added advantage of using taxpayer-funded offices and agencies and officials, and we all know that you can never go up against the federal government because it is an endless stream of resources. Isn't that correct, Mr. Costello?
Without a doubt.
Exactly. If that is not lawfare is, I don't know what is. Lawfare, by definition, is exactly that, utilizing the law to take down your political opponents. It is an abuse of power. Mr. Trustee, you said earlier a pretty chilling statement that you fear we have, quote, crossed the Rubicon, that the ends now justify the means. I feel like many Americans agree with you. Heck, if it weren't for double standards, I feel like our Democrat colleagues in this administration wouldn't have standards at all. But I feel that the credibility of our institution is at stake here because, to your point, the ends somehow have justified the means. You know, I've pulled some research out of a Harvard Law study that suggests that district attorneys pursue crimes and longer sentences at higher rates during election years. So while DA Bragg and AG James' terms end in 26 and 27 respectively, and of course DA Willis is facing re-election this fall, is it crazy to question whether any of these prosecutors are weighing their re-election efforts in their choice as they pursue President Trump? Final word to you, Mr. Trusty.
Right. It's certainly not crazy, and I think that there's evidence that supports that conclusion. And again, I never get to the money part. If you're a prosecutor, you're not supposed to be a politician. You're not supposed to announce your target first and then search for an inventive way to charge them with heretofore unknown crimes in a lot of cases. So that's the problem for me, is not chasing down all the politics of how they stand to gain, but that as a prosecutor, you have a sacred obligation to pursue evidence, not people.
Absolutely, a predetermined outcome.
Correct.
Thank you to our witnesses for appearing. My time has expired. I yield.
Well done. Gentlelady yields back. Gentlelady from Texas recognized.
Thank you so much, Mr. Chair. This is so interesting. A couple of things. I'm just curious to know, as we're talking about lawyers and the obligations of lawyers, and whether or not maybe the former president has any idea of what good lawyer obligations look like. I'm just going to ask, we're not going to play. We're going to do Miss Winebanks. Have you heard of any of these lawyers? I've got Robert Shealy, Kenneth Chesborough, Jeffrey Clark, Matthew DePerno, John Eastman, Jenna Ellis, Michael Farino, Rudy Giuliani, Julia Halia. I got a long list. Have you heard of any of these people?
I have.
Are you aware as to whether or not any of them have faced criminal penalties?
Yes, and also been disbarred or suspended.
Oh, yeah. Okay. So they've had some issues, but these are the handpicked lawyers for Trump. I'm assuming that y'all have never been Trump lawyers, Mr. Trusty or Mr. Costello.
No, I was for a year.
Oh, you were, and you still have your bar card?
I'm sorry?
You still have your bar card?
Yeah, well,
Well,
unless I get targeted for daring to
well,
represent a
listen,
former president.
You have absolutely done a lot better than most that deal with him. So good for you. I also want to make sure that we talk about what two-tier really looks like. And Mr. Trustee, since you've been a prosecutor before, I'm curious to know, have you ever had a criminal defendant that had over 80 counts in 4 different jurisdictions and somehow was not held pretrial? I know that you talked in your opening about your interpretation of what speedy trial looks like, and it's really only for those that are held pretrial. And last time I checked, most of the time those people held pretrial, they don't have anywhere near 80 counts pending against them. But I'm curious to know, in your experience, have you ever had someone that had over 80 counts pending in 4 different jurisdictions and they were not held pretrial? Yes or no?
Well, no specific recall,
Okay, all
but
right.
I could answer
That's all
more if you'll let me.
You told me no, and I understand because I hadn't either. So in addition to that, there's been a gag order, since we're going to talk about the pending trial that's going on right now. Have you ever had a defendant that violated a gag order and then you went to the judge and the judge didn't lock them up and they done it at least 10 times? I think it's 10. I'm losing count right now. Have you ever had somebody violate?
In 35 years, I had never seen a defendant gagged.
Okay, not my question. So you've never.
Well, it's hard to get to the second part if they're never
you've
gagged.
never had it. You're absolutely right. All right. So finally, when it comes down to intimidating witnesses, because maybe you haven't had gag orders, intimidating witnesses, have you ever had a defendant that you were prosecuting and they were intimidating witnesses and they didn't somehow end up in the clank for at least a day or two?
I've had criminal death penalty prosecutions based on witness retaliation. I'm very familiar with gang cases and mafia cases. Most of those defendants were already incarcerated when they would orchestrate some sort of obstruction.
Okay.
If there's provable physical violence-based obstruction, it certainly makes sense that they'd be incarcerated.
Thank you so much. And, you know, Mr. Hamilton, I don't want you to feel left out of this conversation. So I'm going to make sure I ask you some questions. Let me know if you're having problems answering them, because they really should be yes or no. Let's see. You're the executive director for the America First Legal, correct?
That's correct.
All right. And America First Legal is a member of Project 2025, which is dedicated to creating the playbook for the next conservative administration and what it calls the Project Pillars, correct?
We are proud contributors to Project 2025.
Okay. And are you familiar with Project 2025's mandate for leadership?
In fact, I am.
Okay. And in fact, you wrote some of the sections of this mandate related to the DOJ, correct?
Sure did.
And the mandate outlines policy priorities for the next conservative president. Is that correct?
It does.
You've done a great job. I just want to let you know. All right, so let's walk through some of the provisions of the mandate. It calls for eliminating the Department of Education, eliminating the Department of Commerce, deploying the military for the use of domestic law enforcement against protesters under the Insurrection Act of 1807. It also has the repealing of Schedule F status for thousands of federal employees to allow a president to replace career civil servants with unqualified partisan loyalists. That's probably my favorite of it. It also prohibits the FBI from combating the spread of misinformation and disinformation, like Russia and China, who are actively trying to interfere with American elections. I don't know why or how anybody can support Project 2025. And I know that there was allegedly a joke about dictators and whether or not that's funny, but in the United States of America, dictatorships are never funny. And Project 2025 is giving the playbook for authoritarianism as well as the next dictator to come in. And I know that you are doing your jobs here by making sure that hopefully some juror turns on and finds some viral moment of you spewing more of the nonsense as it relates to the president. But as practicing lawyers or licensed attorneys, I hope that we can all agree that no one gets indicted because someone says so. There takes a grand jury, and the grand jury is comprised of American citizens that sit down and review evidence, and they make the determination. And when and if Trump is convicted, it will be a jury of his peers, and it won't be the president of the United States.
I thought you were going to get to a question somewhere in that 90 seconds for Mr. Hamilton after you went after his 2025. I will point out the Inspector General just released a report that said the FBI retaliated against whistleblowers. One of the reasons we do need some changes, but there was no question there. But Mr. Hamilton, if you want to give it some kind of response, you're more than welcome to do that.
Mr. Chairman, my only response would be to say that there are a great number of policy options that have been provided to any future conservative administration through Project 2025. And it's an attempt to restore the rule of law in this country. And I reject the Huffington Post style characterizations of the recommendations.
All right. A gentlelady yields back. The
And
gentlelady
Mr. Chair.
from, we'll go to the gentlelady from Wyoming, then the gentleman from Florida.
Mr. Chair, I'd ask
Thank you.
unanimous consent.
Excuse me, this is, oh,
I'll get you as soon as we go after this thing. Just
Okay.
unanimous consent? Are you
Yes,
gonna-
just unanimous consent to enter the mandate for leadership.
Without objection. Without objection. The
Thank-
gentlelady from Wyoming is recognized.
well, thank you. And if it seems like there might be a dog in this hunt on the other side, what you need to understand is that Mr. Goldman, the novice representative from New York, actually does have a personal stake in this case. He has stated that he has been involved with the Bragg case, helping to prepare Mr. Cohen for his testimony. So he is quite closely aligned with an admitted and convicted liar and perjurer. He's also paid the Judge Merchant's daughter's firm over $150,000 for her services. So I think we've got quite a conflict of interest from Mr. Dan Goldman, the novice representative from New York. And just one other thing to keep in mind when considering the hostility from the folks on the other side of this aisle is that the ranking member
Excuse
of
me,
this
Mr. Chair,
particular
I would move
committee
to have
was
that
Jeffrey
stricken from the record,
Epstein's
to have that
fixer.
phrase taken down.
The ranking member was Jeffrey Epstein's fixer. So I think that that might give you some
Excuse me,
idea of
I
why
would
you
ask
see this
that
hostility.
Hang on, the
statements be
gentlelady,
taken down.
the ranking
to
member is
Mr. Goldman.
recognized.
I would ask that the statements regarding conflict of interest related to Mr. Goldman be stricken down from the record. Engaging in personal personalities.
In your
on this
14-minute
committee.
and 14-second opening statement, you called the former president, current candidate for the office of president of the United States, all kinds of names. I think
He's not a member of this
I
committee.
understand he's not a member, but
And
he's
that's what I'm
still
asking
a former
you related
president.
to.
What I'm saying is we should
I'm
all be
related
careful
to
about it.
our
I think the
member.
gentlelady from Wyoming was just stating facts that are in the news report.
She accused him of a conflict of interest on the committee during the hearing. I ask that that be stricken down.
Gentlelady's point of order is overruled. The gentlelady from Wyoming is recognized.
Thank you. Mr. Hamilton, would you agree that gag orders on trial participants were created with the intent of securing a defendant's right to a fair trial and ensure efficient administration of justice?
It's precisely correct. And it's in fact usually intended to prevent the prosecution from making extrajudicial statements that are going to be prejudicial to the defendant's rights.
And Mr. Trustee, I think that you testified that in all of your years of experience, you've never seen a circumstance where a defendant had a gag order imposed against them. Is that correct?
That's correct.
And would it be fair to say that while such an order is intended to guarantee a defendant's Sixth Amendment right, it also at certain times could raise First Amendment issues?
It does.
Okay. In Bragg's political persecution of Donald Trump, Judge Merchant instituted an unconstitutional gag order against the defendant, President Trump. Yet Judge Merchant has levied no such order against any of the other trial participants like Michael Cohen, who continue to publicly attack Mr. Trump. Mr. Hamilton, is the gag order issued by Judge Merchant a significant departure from the normal order of business? And does it reveal the First and Sixth Amendment tensions which underlie this case?
Most certainly does.
And why does President Trump face such a legally questionable gag order in this case? Well, simply put, it's because it is a classic example of lawfare being employed by Democrats against their political opponent, weaponizing the various branches and levels of government, something that we have seen in the last 8 years that has been absolutely shocking to the conscience. DA Bragg resurrected a zombie case and is using a novel legal theory which has not even been explained to the defendant or the jury. He selected Matthew Colangelo as lead prosecutor, a former Biden DOJ official and DNC consultant, and Judge Merchant, who made campaign donations to President Biden and the Democrat Party during the 2020 election, and whose daughter's firm worked for the Biden and now Harris campaigns, is overseeing the case and imposing speech restrictions on a person Judge Merchant called, quote, possibly the next president of the United States. Judge Merchant went so far in the last 2 weeks as threatening to jail a former president and presumptive major party nominee for violating an order which infringes on his free speech rights. Writing in The Federalist, Tom Christ analyzes how lawfare offers benefits and a means of victory regardless of the outcome of the courtroom, which is causing as much pain as possible and treating the defendant like an enemy versus the defendant. I want that to sink in. Watching Judge Merchant, it is very apparent that he is treating President Trump as an enemy, not a party and not a defendant. Mr. Hamilton, do you think the gag order falls into this playbook and serves an additional lawfare benefit for the left in that it can be used to enact an even larger legal burden on Donald Trump for simply exercising his right to free speech?
Yes, I do. And in fact, quite frankly, when you have a gag order like that, or when you have abuses of processes like this, as my colleagues have alluded to before, the pain in the process is the goal. That's really the goal here. Whether they get a conviction, whether they get any kind of civil fine or judgment, it's not necessarily the ultimate objective. The ultimate objective is to cause pain to the political opponent, and that's what they're doing to Donald Trump.
One of the things that I have observed as an attorney who was a trial attorney for 34 years, is that Judge Merchant is making such blatant reversible errors. He absolutely knows that if there is a conviction in this case, it will be reversed on appeal. And it's as though he is attempting to do that because he knows that no such appeal would actually take place prior to November, yet he would have a conviction on the books, which is the classic, and I think in this case exposes the way in which they are using lawfare against President Biden or against President Trump. I have never seen a judge make the kind of errors that this judge has made in this case before. And I think he recognizes that if there is a conviction, it would be overturned on appeal. That is what our justice system has turned into because of the lawfare being waged by the Democrats. It has to end. Thank you for being here. And with that, I yield back.
Gentleman yields back. The ranking member is recognized for 5 minutes.
Thank you. Now that we've finished with the novice Congresswoman from Wyoming, I guess that's what we're calling first-year members of Congress now, first-term members. I don't know where that came from or what that's supposed to mean. But let's move on. Instead of name-calling, let's just do the work that the people have us here for, whether we like individuals or not. Which sounds ridiculously immature. There was a discussion earlier about Jack Smith, and it was alleged that he is engaged in bias, partisan actions before. Is the discussion, I went and looked at some of the cases that he has, in fact, taken up in his long career, both in New York, Brooklyn, as well as at The Hague. Ms. Winebanks, are you familiar with former Representative Rick Renzi? He was a Republican member of the House that this Jack Smith prosecuted. Are you familiar with the name Senator John Edwards? He was a Democrat that Jack Smith also prosecuted. Republican member, Governor Bob McDonnell, when he was in the office of the prosecutor at the International Criminal Court of The Hague, many individuals from all world parties and leaders. Are you familiar, I don't know if you're familiar with an individual named Ronell Wilson.
I am not.
Ronell Wilson was an individual in New York who murdered 2 New York City Police Department officers. That was prosecuted by Jack Smith. He also prosecuted, however, police who brutalized Abner Louima. I'm sure you're familiar with that name.
I am.
So this is an individual who seems to be a prosecutor willing to go after anybody, no matter what their party is, if, and reviewing and investigating the information, they believe that that person has broken the law. And that's what I call a good prosecutor, having been one myself. Mr. Hamilton, are you aware that Chairman Jordan filed multiple amicus briefs in the case of Missouri v. Biden, now called Murphy versus Missouri?
I am.
And in fact, you are the attorney of record on those briefs, is that correct?
I am one of the attorneys.
Okay.
Correct.
Thank you. Were you provided access to the committee's transcribed interviews and deposition transcripts as part of the work and preparation of those briefs?
I was provided with, yes, information. Absolutely.
And that included transcribed interviews and depositions?
I was provided with lots of information. I'm not going to get into all the details here because doing so would reveal the existence of communications between an attorney and a client.
Okay, that's fine. Do you, in your briefs, one of those instances of those briefs, you claimed that the FBI witness told the committee that the supposed Biden laptop was real, quote unquote, suggesting that the FBI had authenticated it. Do you recall that?
Do you have the brief in front of you?
Yes.
Could you read it to me? And I'll let you know if I recall it.
Okay, can you hold the time for me, Mr. Chair?
Sure.
Thank you. Page 21. Is it which one? Okay. I'm reading from the brief on page 28. of the brief that's listed, brief representatives Jim Jordan, Kelly Armstrong, Andy Biggs, Dan Bishop, et cetera, that was filed with the court on page 28. It states that, but of course the FBI knew not just the absence of evidence suggesting any foreign connection, the FBI knew the laptop was real. Do you recall that?
I do recall.
Okay. Do you also recall that when the individual stated, the witness later said that, suggesting that the FBI had authenticated it? However, that completely ignored the fact that the witness later said in that same transcription, that same interview, that anyone who claimed that the laptop had been authenticated would be, quote, misrepresenting her testimony. Do you recall her having said that?
I can't tell you today if I recall that or not.
Okay, so your brief suggests that one particular nonprofit, well, your brief then does not give the whole story by stating that the individual said the laptop was real from the FBI, misrepresenting that it had been authenticating, when she just meant that it existed, not that it had been authenticated. Do you know that difference?
Are you disputing the reality of Hunter Biden's laptop?
I am disputing your brief, which makes it seem that the authentication of what was in the laptop was there.
But so I'm trying to understand where you're going. Are you trying?
just asked
Are
the
you
simple
disputing
question.
the contents of Hunter Biden's laptop?
I am disputing that it
purpose
had
of
been
your question of
authenticated
me?
by the FBI. Do you know if it had been authenticated by the
Whether the
FBI?
FBI authenticated it or
You said
not,
it
the
had. You
existence
said it
of
had.
it, it was authenticated
You
because
said
it
it
was
had
real.
in the
What you're
brief.
getting into.
You said it
word
had in the
jujitsu.
brief. That's the point. Moving on. I could go literally for hours. Your brief wrongly suggests that one particular nonprofit is in fact a government entity, and even includes a graphic from that nonprofit website that was cropped to omit language stating that the nonprofit is autonomous, meaning it's independent from the government. Literally on and on. It's just like this hearing of misrepresentations of the truth. I yield back.
Gentlelady yields back. I would point out that last week the committee deposed Mr. Brady Olson, FBI agent, who said that at the time, October 2020, the FBI had no evidence that the laptop story was a hack and leak operation. No evidence. So they had done exactly what Mr. Hamilton described in his written brief. I now recognize the gentleman from Florida, Mr. Stubbe.
Thank you, Mr. Chairman. Yeah, just to.
Hang on one second, Mr. Stubbe, if you would. I understand you have a hard stop, Mr. Hamilton. We wanted you to be able to stay for, any Democrat want to ask you a question. If you got to run, we understand. If time's now, Mr. Stubbe.
Thank you.
Thank you.
All right, so you're taking off? Mr. Hamilton's taking off? All right, so Mr. Costello, I'll just start at page 6 of your written testimony. I know the chairman got into what Mr. Cohen said about, I swear to God, Bob, I don't have anything on Donald Trump. And then after that, so I'm at the end of page 6 of your written testimony. And I just want to walk through this. Through further cross-examination, Cohen told me that he knew there was money missing from the Trump inauguration fund, but that Donald Trump had nothing to do with it. Is that correct?
Where are you referencing on page?
I'm in your written testimony
Right.
on page 6 at the bottom.
Okay. And you're referring to what again?
I'll just read it. Through further cross-examination, Cohen told me that he knew there was money missing from the Trump inauguration.
I see where you are now. Thank you.
Okay, and then on the next page, into that first paragraph, Cohen decided that while he didn't believe the allegation of the Stormy Daniels story, that he thought the story would be embarrassing for Trump and especially for Melania, so he decided he would take care of it himself.
Absolutely. And that is contrary to what this guy testified to in court in New York yesterday.
Well, and what's not being talked about is your next paragraph, like the reason and his motivation for that. So if you could just kind of walk through that for the committee.
Yeah, obviously, when we started to talk about the NDAs, and this is the very first meeting at the Regency Hotel, when, by the way, Rudy Giuliani was not involved in representing Donald Trump at that time. Cohen testified that it was a conspiracy between Giuliani and Costello as of this date. Totally false. In any event, he also said that he didn't discuss the Stormy Daniels matter with us, and he certainly did. I specifically asked him, because he kept on going back saying, I can't believe they're trying to put me in jail for these NDAs. So I said, Michael, tell me about the NDA. Tell me about Stormy Daniels. What did you do? He said, I got a call from a lawyer representing Stormy Daniels who represented that she was going to testify that Donald Trump had sex with Stormy Daniels. Michael Cohen said, I didn't believe the allegation, but I knew that such an allegation would be terribly embarrassing. He said it would be embarrassing. He focused on Melania Trump. He said, I didn't want to embarrass Melania Trump. He said, that's why I decided to take care of this on my own.
Right.
I went back to that several times. You did this on your own? On my own. Did Donald Trump have anything to do with it? No. Did you get the money from Donald Trump? No. From any of his organizations? No. From anybody connected to Donald Trump? No. Where did you get the money? I took out a HELOC loan against my property. I said, why would you do that? He said, I didn't want anybody to know where I got this money. I didn't want Melania to know. I didn't want my own wife to know because she's in charge, he said, of the Cohen family finances. He said, if she saw money coming out of my account, she'd ask me 100 questions and I didn't want to answer any of them. It was clear after talking to him for several days after that, whenever we talked on the phone or in my office, that he kept on bringing up the subject that he felt he was betrayed by not being brought down to Washington, D.C. This guy thought, he said to me, that he should have been Attorney General of the United States, or at least the chief assistant to the president. Ludicrous, but that's what he thought. And he was very angry about that. He wanted to do something to put himself back into the inner circle of Donald Trump. That's why he took care of this on his own. There had to be a motivation. Michael Cohen is always working for things that benefit himself. And that's what he was doing here. That's completely different to what he said that he told the grand jury. That's completely different to what he's testifying to in New York. Nobody has heard this side of the equation.
Right.
When
Which is, I think, is important that you're talking about that today. And I'm now on page 8, but just to keep, we're going to keep going from where you were in your written testimony. The point is, when Michael Cohen was presented with the opportunity to implicate Donald Trump in exchange for eliminating his own enormous legal problems, he repeatedly said he had nothing truthful on Donald Trump.
Yeah, why is that important? It's important because this guy literally was suicidal at the moment. He's saying, guys, I need you to tell me what my escape route is. How do I get out of this oncoming legal deluge that I see coming my way? And so I said, look, it's simple. If you look at what happened here, the U.S. attorney went to great lengths to get a search warrant for your law office. They had to go to Main Justice. They think you have something. Remember, he's telling us I didn't do anything illegal. Counts 1 through 7 that he pled guilty to had nothing to do with Donald Trump. He said, I didn't do anything illegal. And I've been cooperating with the special counsel. I've been cooperating with Congress. Didn't tell us that he lied to Congress. I said, Michael, isn't it easier if you have something truthful? And I kept on repeating that. It's got to be truthful. Don't make something up. If you have something truthful on Donald Trump, isn't it easier for you to cooperate against Donald Trump than it is to kill yourself? The answer is obvious. So when they claim that I was trying to shut up Michael Cohen, it's exactly the opposite. I was on that first day telling him, here's your escape route if you have truthful information, but he didn't.
And at this time, you were his attorney, which is why he made all these admissions.
Yeah, I mean, he makes these claims that we were never his attorney. I can show you emails and text messages and phone calls where he kept on saying, Bob, you guys are on the team, but I don't want to announce it now. He had McDermott, Will, and Emery going through documents here in Washington, D.C. He said, I don't want to announce it now. We didn't give him a retainer agreement the first time we met him at the Regency Hotel. We gave him a retainer agreement when he came to our offices. He came to our offices that he kept on saying, well, I can't deal with this now. The guy slow played us. There's no question about it. And I told the partner in charge of this, he's slow playing us. Get rid of this guy. He's never going to come up with the money. He's a bad penny. He's just going to keep on coming back. So it wasn't my call because it was his client, not my client. So that's why Michael kept on calling me, and I was giving him the advice that I should have given him all along. Truthful advice. Nobody was pressuring him. I was giving him the straight facts as I knew them.
My time's expired. I yield back.
Gentleman yields back. The gentleman from North Dakota is recognized.
Thank you, Mr. Chair, and I'd yield to you.
Thank you. I thank the gentleman for yielding. Mr. Trustee, 17 years at the Department of Justice. Did the raid on Mar-a-Lago follow normal process?
I don't believe so.
You know who agrees with you? the assistant FBI director of the Washington field office, because we deposed him. And I just want to walk you through and say if what you saw squares with what Mr. D'Antuono testified to in a deposition in front of the committee. The Miami field office did not conduct the search. It's folks from Washington who came down and did the search. Is that unusual?
I would think so. You normally have at least some local component.
The department did not assign a U.S. attorney to head up the investigation. They ran it out of the field office. They ran it out of Washington, D.C. Is that unusual?
Well, I'm not sure it's unusual for DOJ attorneys to kind of assume authority in a vacuum. So, my understanding is Jay Bratt was involved from day one, and that continued through the search warrant, obviously.
Right, but normally wouldn't a U.S. attorney be assigned to it in most cases?
Yeah, and eventually they would show up for court, but I don't think at that part of the process they were an active partner.
Did the FBI seek consent before they conducted the research or the search?
No, actually, the last thing that President Trump said when he allowed FBI agents in Mar-a-Lago in June was, anything you need, let me know. The only communication that came from DOJ after that was a request to put a padlock on the door where they knew the boxes were. And then the next thing we know,
Which the president complied with.
Which he did immediately. And 2 months later, there's a search warrant.
And then did the FBI wait when they got on premise, had it secured? Did they wait for President Trump's legal team to be there and accompany them on the search?
There were requests by representatives of President Trump to be, in the vicinity of the search. Those were denied. That is a right of law enforcement. They don't have to. But for a case of this historical precedence, consistent with my earlier remarks, some transparency, some openness would have been probably a valuable moment lost here.
No kidding. Talk to me about, in your testimony, two other things. You mentioned the 14th Amendment. I mean, this to me struck me as just absolutely craziness, that they're going to go to state courts and try to keep the president off the ballot. Tell me your thoughts on this crazy concept.
Well, the Supreme Court unanimously agreed to end the nonsense of the disqualification litigation, but they never really reached the due process, which would have been a hornet's nest of going state by state and saying, how did they conduct these expedited trials? The fact that always grabbed me, and maybe this goes back to having a bad sense of humor, was in Colorado, they literally put a sociologist on the witness stand to say, when President Trump said, go peaceful and patriotically, I know from my Ouija board or whatever else he consults, that he really means be violent and attack the cops. I mean, that was considered admissible information in a hearing designed to take a presidential candidate off of a ballot. So I kind of wanted the Supreme Court to get the due process and join me in laughing at that, but they never got there.
Yeah, what he said, I've concluded, means exactly the opposite, and the court accepted that as evidence. Thank goodness the Supreme Court said 9-0. This is crazy. I want to read you one other thing from your testimony, which I just found amazing, and you briefly touched on it earlier. You said, if this is in grand jury situation, in the grand jury, the prosecution said to Mr. Parlatore, if the president is being so cooperative, why won't he waive his attorney-client privilege? The fact that they asked that question in a grand, is, again, maybe as crazy as the whole 14th Amendment argument.
Yeah, I mean, again, nothing I'd seen in 35 years. And it was an over-aggressive moment of asking the grand jury to draw a negative inference from a lawful invocation of attorney-client privilege. That's just black letter unethical for a prosecutor to do.
Yeah, scary, scary stuff that we see going on, all to go after their political opponent. And we could go on with example after example. I mean, the one before where dangling the judgeship in front of a lawyer representing, when you got Jay Bratt and the DOJ there, is just, again, we could go on and on. I want to thank you both for testifying, and would yield back. The chair now recognizes the gentleman from Ohio, Mr. Davidson.
I thank the chairman. I thank our witnesses. I regret that I didn't have the chance to dialogue with Mr. Hamilton, but I thank you guys for being here and staying a little longer than we thought the hearing would run. Look, one of the most influential books that I've read is a short book called The Law by Frederick Bastiat. He was a French philosopher in the 1800s. He predates Karl Marx, and he was addressing the socialists. So they were already trying to weaponize law. His book about the law was, in fact, all about how the law was corrupted and perverted from its proper use of defending freedom and property rights
to a form of corruption, legal plunder, as he termed it. One of the quotes from the book is he says, when law and morality contradict each other, the citizen has the cruel alternative of either losing his moral sense or losing his respect for the law. And I think that's where the American people are. They see that the law has been corrupted and perverted. They see at best a two-tiered system of justice. One of the most common questions probably every member of Congress gets, certainly when I talk to my closest friends, we all get this question, Congressman, when is someone going to jail? Now, to be fair, when the Democrats ask it, they want to know when a Republican's going to jail. And when the Republicans ask it, generally they want to know when a Democrat's going to jail. But the reality is people are seeing that there's one standard that they would be held to and another that's being applied to others. Political enemies, overwhelmingly. Political rivals. It's the weaponization of law, lawfare. And the tip of the spear of this is Donald Trump. You know, Donald Trump, they mocked when he said that they were spying on his campaign. Lo and behold, they were spying on his campaign. They said that the Russia collusion thing was all fake. They funded a $30+ million investigation into Donald Trump with the Mueller report, and people still think that's what he was impeached for. It was a nothing burger. No crime, no action. In fact, to the extent there was a crime, it was done by firms like Perkins Coie that rigged this whole hoax. It was against our national intelligence community that weaponized their trusted position in the intelligence and law enforcement community to spy on the presidential campaign of Donald Trump. Now we see election interference in a different way in this campaign. We've got a case where we've seen, whether it's Alvin Bragg, Letitia James, others, that campaign on a platform for election of going after Donald Trump. Fani Willis raised money off of her criminal case against President Trump. Finally, Mr. Costello, I enjoyed your dialogue. And would you agree that these prosecutors are, in fact, politically motivated in their targeting of Donald Trump?
Without a doubt.
You think about the case in New York, Alvin Bragg's case. I mean, what is the crime? And to the extent there was a crime, how does it relate to Donald Trump? Could you elaborate?
Nobody knows what the crime is. They've taken a misdemeanor, which is barred by the statute of limitations, and tried to turn it into a felony by saying the misdemeanor was used to cover up an additional crime, the felony. It's hinted that the felony that they're trying to cover up is election interference for the 2016 election. They claim was caused by false entries made in 2017. Now, how do you influence a 2016 election with 2017 allegedly false entries? They say, because I was puzzled by this, it's a conspiracy. Really, said I. I went and I pulled the indictment. There's 34 or 38 counts. No conspiracy count. One defendant, Donald Trump. It's absurd.
The whole case is, but yet in spite of that, and in spite of the fact that the world sees through this, we're all wondering whether or not we'll get a not guilty verdict to the extent we get a verdict. We don't trust that the law is actually going to be administered impartially. We're not sure that you could get an impartial trial of his peers, a jury of his peers. And this is the thing. Our criminal statutes are designed to protect the defendant. We've seen a clear abuse of the law. We've seen, as I point out, nothing new under the sun. And, you know, it's not like Bastiat was the first person to discover this. We've seen the first thing, basically, don't hurt people, don't take their stuff. Because humans have a hard time with that, we started pointing someone to be the judge. Who was the one in the right? Who was the one in the wrong? People see through this, and they're going to see it on November 5th. And I just trust that this country is worth defending. And I applaud the people that are standing up against injustice. Mr. Chairman, I yield back.
Gentleman yields back. Well done. The gentleman from South Carolina is recognized for 5 minutes.
Thank you, Mr. Chairman. Here's what I think is abundantly clear. The Democrats will do and are doing everything in their power to keep President Trump off the ballot or from winning. Nothing is off the table. Things I'd never imagined or even thought were remotely possible are now happening in the United States of America. You name it, and they're doing it. They're taking the decision away from voters
by outright stripping his name off the ballot. Of course, the Supreme Court rightfully intervened there, but you had unelected secretaries of state, unaccountable judges making these decisions. They spied on his campaign, as we've talked about. They abused FISA, fabricated documents, and relied on a paid-for campaign dossier to spy on his campaign. Again, falsely alleging that there was some Russian collusion, which has been debunked over and over again. And the most egregious yet, we have not one, not two or three, but 4 politically motivated cases that are happening all around the country. Again, it's to keep him off the campaign trail, it's to smear his reputation, and it's to drain him of resources. This is a targeted, this is a meticulous effort and a plan of attack to usurp the will of the people. Again, at the expense of our own institutions. That's what's most troubling to me as a lawyer, is that we're using Article 1 to attack him. We're using Article 2 to attack him, and now we're using the courts. These local prosecutors should be focused on cleaning up their streets, cleaning up their communities, stopping people from getting shot on the subways, and prosecuting real crimes, for goodness sakes. But we don't have that here. We have Donald Trump, right? Let's go after him. Mr. Chairman, I'd like to enter into the record an article by America First Policy Institute called "Progressive Prosecutors Abusing Their Power."
Without objection.
You know, in Georgia, Fannie Willis brought charges against President Trump immediately when he announced his reelection. I guess there's so much bandwidth in her jurisdiction that she can take taxpayer-funneled vacations with her lover and ignore real crime that is happening because there's just not much to do in Georgia. But that kind of belies the case. We have, she oversees, quite frankly, according to this article, a top